Hello, my name is Stefan Kröll and I'm professor at Bucerius Law School in Hamburg, Germany. I'm the director of its Center for International Dispute Resolution, and in addition, and that's probably the function which most of you will know me, I'm one of the directors of the Willem International Commercial Arbitration Moot. In that function, I'm responsible primarily for drafting the case, answering your questions, and then destroying your first argument by procedural order number 2. Unfortunately, I will not be able to meet you either in Bahrain or in Vienna in person. You can imagine that for the organizer of the Bahrain Pre-Moot, but also for us, it has been a very difficult decision to take to cancel the oral hearings. But let's look at the positive side. Thanks to the efforts of Ron Brandt and the team of the Commercial Law Development Program, the educational part, which is for us the most important part, can now largely be delivered online. What cannot be replicated is the equally very important social part. The educational part can be replicated in both its parts, the lecture part and the competition part. And while I'm giving you a lecture now, I hope to see at least some of you in the finals of the competition part. It probably does not come as a great surprise to you that given my role in the moot, I will not talk directly about the legal issues involved in the case. Anyway, by now many of you and your coaches are probably much more familiar with the problems than I am. So I could hardly provide any additional input going beyond the arbitrator's brief. Instead, I will try to give you some insight in how such a case would be treated in practice by the parties, their counsel, and the arbitrators. This case has naturally been inspired by some real cases I had as an arbitrator, which involved cavitation and corrosion in water turbines and other technical equipment. Naturally, the case, not only for confidentiality reasons, but also for reasons of making it a proper moot case, has to be modified considerably. So the only thing which remains is the practical or factual problem of corrosion cavitation. In every moot case, also in this case, you find some agreements which you will rarely find in practice, such as the agreements in procedural order number 1, Roman 2, where the parties have made some agreements concerning, for example, the expert opinion of Mr. John or the continuation of production, which show that they really cooperate. But in the end, arbitration is all about party autonomy, and there are few limits to the creativity of the parties or the arbitrators. And in my experience, parties and arbitrators should often be more creative to reach the goal of a cost-efficient dispute resolution, which at the same time maintains the relationship of the parties as much as possible. There are very few parties who earn their money by litigating or arbitrating. The majority earns their money by the economic ventures underlying the contracts and by future business with the same parties. In this case, we have a situation where the parties will most likely cooperate in the future. There will be further inspections and there will be maintenance work for the turbines. And this maintenance work has to be coordinated between the parties, and a proper relationship, a good relationship between the parties is of considerable importance. And second, there will be the potential for future projects. On the one hand, we have one of the biggest operators of water reservoirs and hydropower stations. On the other side, we have one of the leading producers of turbines. And since it's a narrow market, it's very likely that they will cooperate in further projects. Now let's come to the stages I would like to discuss with you. The first one is the stage for claimant after the negotiations had broken down. Then the claimant has to make a decision whether to go to arbitration or not. And in that decision, he first has to determine his interests. Second, claimant then has to analyze the option available to it in light of the interest defined and the contractual provisions agreed upon. That also involves a risk analysis of the chances of success and failure for each of the potential options. And in light of that, claimant third then has to devise a strategy. That is the ideal world, and that is what dispute experienced clients do. However, in practice, often you see cases where the parties have not defined their interest, where they have not really looked at the options available, but have been driven often by their lawyers who wanted to litigate the case in a particular environment because that is the environment they're familiar with. They are driven into disputes which could have been avoided. Let's look at the present case again. The present case is peculiar in two issues. First, claimant is asking for the replacement of a turbine before it has even been determined with some certainty whether the existing turbine is affected by corrosion cavitation. That is one of the problems in the substantive part of the case. Is it sufficient that there is the risk of the corrosion and cavitation to make the turbine non-conforming in the sense of Article 35? And the second peculiarity is that the decision has to be made in time, so that the respondent, if it's ordered to produce the turbine, can do so before the inspection takes place, that the turbine is available at the inspection time. Otherwise, the task or the request by claimant is frustrated already by the timing of the decision. Claimant has an interest thus to have an early dispute resolution, an early determination that respondent has to provide a new turbine and can start operating and working on the turbine in time. When looking at the dispute resolution clause in Article 21 of the contract, they give claimant two options. The first one are the courts in Mediterranean. That would definitely give claimant the home court advantage. The question, however, which arises, are these courts sufficiently fast? Will they render the decision in the time required by claimant? A minor issue in the present case, given what I've just said before, the need for further cooperation, is the enforcement of a decision. But in other cases, often enforcement is an important issue which you should consider already at the time when you start an arbitration or a litigation. It doesn't help you in the end to get a decision which you cannot enforce against the other party due to the lack of any international agreement guaranteeing enforcement or bilateral agreement between the parties. It's clear that the court option would probably also not face any legal problems because both parties have submitted to the courts in Mediterranean. irrespective of that, the speed of the decision-making process will probably exclude the courts in Mériterneo. That leaves claimant with the arbitration option. However, the arbitration option is a unilateral option which has been granted only to claimant and does not exist for respondent. There are jurisdictions in which that renders the arbitration agreement invalid, or at least gives the other party to bring an arbitration as well. You will discuss that in detail in some of the jurisdictional lectures, and it is a problem here that the applicable laws may not be those upon which respondent wants to rely, but on the other hand, respondent invokes a principle which you find also frequently in international conflict of laws and others, that a party should be protected by the rules it's familiar with. Whether that applies to arbitration or not is something you should have to discuss. Let's come to the second point, the experts. Cavitation and corrosion are sufficiently complicated issues that it's highly likely that the tribunal will not be able to decide the dispute without any guidance from experts. However, claimant did not appoint its own expert yet and did not submit an expert report with its statement of claim. What claimant tried to do was to appoint an arbitrator which had considerable experience. What could be the reason that claimant did not appoint its own expert, did not present an expert report already with its statement of claim? The other side did offer an expert report. So there is an obvious need for these type of expert reports. However, claimant may deliberately have decided not to do so, hoping that in the end there would not be two party-appointed experts, but there would be a tribunal-appointed experts, which would then be interrogated or examined at an oral hearing by the parties with the help of their experts. That may save time because there is no battle of experts. And it may be a strategical choice by claimant. In particular in areas where you have very few experts available, there's also a strategy sometimes to basically burn the experts in a way. Meaning you approach several of the experts, give them some information, and then when you retain one of them, the other ones can hardly be used by the other side because they have been provided perhaps with confidential information. And in the areas where you have few experts available, it may be very difficult in the end to find experts which have no contacts with any of the parties. The problem with a party-appointed expert is that it's rarely regulated in the arbitration laws or rules. It's much less regulated than tribunal-appointed experts. That raises one of the questions, which may play a role in this case as well, but is claused in a slightly is looked at from a slightly different angle. Under which circumstances can experts be challenged or removed by the tribunal if they have been appointed by the parties? As a tribunal, it can probably not prevent the parties from appointing the experts. That would probably be a violation of the right to be heard. But as a tribunal, on the other hand, you have the opportunity to structure the procedure within your procedural discretion in a way that you want to rely on a tribunal-appointed expert. So for the tribunal, it's always a decision: do you prefer a battle of party-appointed experts, or do you prefer a tribunal-appointed expert? The danger with two-party appointed experts in areas where you have different methods, different ways of calculating issues, different models, is that both experts take a completely different model, render expert reports, and it's like ships passing at night. The tribunal has two completely opposing expert reports and is as informed as it was before. In the present case, time is an issue. So for the tribunal, it should understand that the decision has to be rendered in time that respondent, if ordered to do so, can still produce the turbine or the turbine runner before the inspection takes place. So for the tribunal, it may be important to get a non-expert, or at least get a strong engagement in trying to find a common ground for the party experts. Thus, in a case like ours here, a tribunal would probably sit down after the statement of claim or after the request for arbitration and the answer to it have been exchanged, and then try to agree with the parties on terms of reference for either the parties' experts or a tribunal-appointed expert. The advantage of a tribunal-appointed expert in the present case would also be that you could perhaps avoid the appointment and the problems resulting from that by Mr. John. However, as I said, it's very difficult to prevent a party from appointing its own expert. So what you would do probably is just reduce the problem, but not avoid it. And that is where I would like to end. It's like with the coronavirus. While we cannot ignore it or completely avoid it, we try to minimize its effects. I hope that through these lectures, through the online Moot, you get at least a certain WIS experience and get at least most of the educational exercise. And to allow you, and to allow those of you who have learned sufficiently and who have the sufficient luck to make it into the round of 64, to allow those also to have a proper Moot experience with meeting colleagues, arbitrators, and other teams in person. We have waived the rule that those who are progressing to the round of 64 cannot participate in next year's Moot. So you can participate in next year's Moot, but first of all, I wish you all the best for first the Bahrain pre-Moot and then the Vienna event, and hope to see at least some of you either in the final of the Bahrain pre-Moot, in the final or other rounds of the Vienna pre-Moot, or in practice in either lectures or in arbitration cases where you could use all the knowledge you have gained during this exercise. All the best, and I look forward to meeting you in person. Bye.